Welcome back to Pace Immigration, paceimmigration.com, talking with Michael O'Rourke, freshly back from South America. Michael, how was your trip?
Hi, Sean. It was pretty good, actually. Lots of meat, lots of talking, lots
Yeah.
of flying, but it was really good.
Now, the reason we're going to talk about this issue that we have on the screen right now with the intracompany transfers is because you were doing a lot of talking about that while you were on your trip. Go into that a bit.
Exactly. So I have some existing clients in the southern cone of South America. And one thing that we as business immigration lawyers use all the time is this intercompany transfer program to bring somebody from abroad who's working in a company outside of the US or Canada and to bring them into the US or Canada. There are some requirements to do so, and there has to be a specific company relationship between a foreign entity and a US or Canadian entity. But it's a really good way if you are a manager or an executive or an owner of a company or a specialized knowledge worker in a company to come to either the US or Canada and to work.
Right. I've got the graphic here, of course, coming over to the US and Canada. We should say off the bat that there's two different programs. Obviously, Canada and the United States don't share a program, but they each have a program and they're very similar. We're going to talk about the one in the US first. We have the L1A intracompany transfer, and I have here executive or manager with a few points here. Michael, go into the L1.
Sure. So the L1 is the general intercompany transfer. L1A is reserved for managers or executives. If you have been a manager or an executive in your foreign company abroad for at least a year, and within the last 3 years of before you make your application to the US, you can transfer to a related entity in the United States. So, a couple things to unpack here. A manager has very specific duties and has to manage professionals. There are a number of criteria that USCIS sets out for determining whether a person is truly managerial. The same goes with an executive. An executive has very specific duties and responsibilities in an organization, and USCIS will manage or will review the person's daily job duties to make sure that they fit within that box. And managers and executives generally can come to the United States for a period of up to 7 years to run or manage the company in the US.
Right. One that I thought was really key, which kind of interesting, and I didn't really realize this until I started looking into our notes again. You can also, it doesn't necessarily have to be that there is an established business in the US, does it? Because it says here, you can also send someone to establish something in the United States.
So the legal structure has to be established. You have to
Okay.
have a qualifying relationship, which means that your foreign company and your US company has to either be a parent subsidiary or affiliated. It all goes down to ownership and control. Does one entity own and control the other entity? And that's what another criteria that USCIS looks at.
Now, you've done tons of these cases. In your mind, is it fairly straightforward, provided the person has their qualifications? Is it a case of just filling out the right paperwork and getting it done, or is there a lot more fact finding that has to go on?
Well, there is a lot of evidence that these applications require, and USCIS especially likes to ask for more evidence once we've filed them. But if the relationship between the entities is clear, if the job that the person is doing fits into these categories, if they're qualified to do the job that they do, then yes, it is pretty straightforward. It's really the bread and butter of an immigration law practice.
That's interesting. How many and just as a ballpark, how many cases of these like these have you done? L1s.
Gosh, this month. Um, yeah, let's see. I currently probably have about 25 or 30 L1s just sitting on my case list, but over the years, hundreds, maybe
It's a
low thousands. Yeah, there are lots
yeah.
of them.
That's a lot of bread and butter. Yeah, you're
Oh,
right.
it is.
Okay. So let's say everything goes smoothly. The person is qualified. All the legal structure is in place for both the U.S. and the foreign entity, and the person is going to come to the United States. Obviously, someone who's reached that stage in their career probably has a family or could have a family. Let's talk about then how the family can come over.
Sure. So the family can come over at the same time, or they can come after the main applicant has gotten their L1. So an L1's A, or actually an L1B spouse, can work without any additional documentation other than proving that the spouse is indeed the spouse and that they're legally married. The U.S. requires legal marriage, where Canada does not. It's a little point of distinction. But
Interesting. Yeah.
yeah, and that for our Canadian clients who wish to come to the U.S., that's one of the questions I'll ask is, are you legally married? Because in Canada, we have a stronger tradition of common law relationships. And the
Interesting.
Canadian government recognizes those where the U.S. does not.
Right. And talk a little bit about children as well.
So children can come as well as long as they're under 21. They will get L2 status just like the spouse. They are not permitted to work, however. They can go to school on an L2, though.
Okay. What happens if the child, after the child is 21, say they come over, they're 18? You said that you can get a 7-year pass to work in the United States. What happens when the kid does turn 21?
Well, then we have to look at other strategies. And if the kid is going to university, one thing that we might do is change their status or have them leave and come back into the US and get an F1 student visa. Otherwise, if they're not going to do that, and if there hasn't been a petition for their permanent residence that's already been filed, then they age out. And the only way they could stay in the U.S. for a short term is to be a visitor.
So obviously, this is something you're going to cover with a client that has
Yes.
children. Yes, absolutely. Okay, let's move on to the Canadian version of this. Canada has something very similar, but it's not called an L1, obviously, because we're talking about Canadian law. Talk about this, and I had to put the whole title here because I think it actually gets across that the Canadian version is a little different. It says here, the International Mobility Program, Canadian interest, significant benefit. I know you're key on that for an intra-company transferee. Talk about that.
Yeah. So, as the title suggests, in Canada, this is slotted under Section 204. And this means that an intercompany transfer has to provide some benefit to Canada. And as you've got up on the screen, improving management effectiveness, expanding Canadian exports, expanding or enhancing competitiveness in overseas markets. These are different ways of slicing and dicing what significant benefit to Canada could be. But in any application that we make for intercompany transfer here in Canada, it has to have that element.
Okay, and you've got to be able to show that. I noted here as well from the government. This is from the Canadian government's mouth. Qualified intercompany transferees require work permits, but they're exempted from the labor market impact assessment. That's interesting.
Yes, and that's one reason why we love these things, because labor market impact assessments, LMIAs, are just miserable.
Right.
So if there is any way that we can avoid going through the LMIA process, we'll look for that.
For the uninitiated, if you don't mind, I'll just put it in lay terms that the LMIA is basically that's the route you have to go to show that a Canadian couldn't do the job and that you exhausted all those possibilities. Is that right?
Exactly. To get a work permit, the standard default is LMIA. If there are certain ways to avoid the LMIA process, intercompany transfer being one of them, but if there is no way to avoid the LMIA process, what you generally have to do is advertise a position for 30 days. You have to make an application to Service Canada. Their officers will review it, question your clients, and make you show that this foreign national that you're trying to bring into the country to work in this position is actually not only qualified, but that there's no Canadian citizen or permanent resident who would be available to take that position.
Right. But the obviously what we're talking about with the intracompany transfer, that skips all that. You don't have to go through the LMIA process.
Yes, exactly. And that's because of your pre-existing relationship with the company. It's assumed in this intercompany transfer type of situation that you're going to have knowledge of the company and the way it does business, its practices, its methodologies, etc., that are going to benefit the economy in Canada, or at least benefit the company in the United States, by bringing you over and having you work for the company here for a limited time.
Right. I just put up here the big cheeses is what they're looking for. That's why we've got that graphic there. The qualifying job positions, executives and senior managers, functional managers. And I highlighted this one here, specialized knowledge workers. I think most people can get their head around more or less what an executive and a senior manager is, and a functional manager. I mean, you'll go into that with them as a client, of course. But specialized knowledge workers, there's some caveats here, and I've got it on a screen here. Talk about this a little bit.
Yeah, so both in the US and Canada, although this slide uses US terminology, they're looking for somebody who has a significant amount of knowledge about a certain thing. So if, for instance, you're going to want to bring a mining engineer to your mining company in Canada, and that engineer has been working abroad, maybe not in any sort of managerial capacity, but they could have been working in a managerial capacity. It doesn't exclude people who have management responsibilities abroad, but what they want to see is that you have certain specific knowledge in a professional field. So this usually means that they'll want to see a bachelor's degree level of education or higher, and that you have knowledge that is not common. So if your only specialized knowledge is that you know how to make Excel work, which maybe in our office that would be specialized knowledge, but otherwise, if you have to be able to talk the talk and walk the walk. You have to be able to show that you can use your knowledge, and I hate using specialized knowledge over and over again, but this very specific knowledge about this field of endeavor, this field of professional work, to further the company's goals.
Right. You know, you could spend a long time, well, not you specifically, you know all this stuff, but I spent a long time going through pages and pages and links on the Canadian government website that talks about not only the management roles, but also this specialized knowledge. And they boil it down to basically, it's not enough that you know how to use an off-the-shelf product that the company produces. You need to be a driver behind why it works, and maybe some new versions of it and things like that. It's got to be very in-depth knowledge. Yeah.
Exactly. And so one of the issues that my colleagues and I have seen in the past, you might have an SAP developer who wants to come in and do a work assignment in the United States, for instance. And other than their expertise with SAP, they don't have much else in the way of specialized knowledge. And USCIS for the longest time was saying that no, even though you might know SAP, you might be able to program and develop unique operations and unique what's the word I'm looking for, unique applications with it for your company, that did not actually rise to the level of specialized knowledge. So
Right.
it can sound like splitting hairs to clients, but some specialized knowledge is more valuable than others, at least in terms of the government functionaries who are looking at these things.
Which one's more difficult, Canada or the U.S.? Because when I was reading the American stuff on the U.S. website, they didn't go into as much detail. The Canadian website on the government website went into way more detail. Is that a trap? Am I thinking that the American version is easier and it's not?
No, probably because you didn't see all the memos from USCIS explaining exactly what specialized knowledge is. The
Okay.
US likes to hide the ball a little bit more and surprise you.
Right.
No, I would say actually, on balance, it's pretty similar. The benefit of coming to Canada as a specialized knowledge employee or even as a manager or executive versus the US is that for Canada, if you're from a visa exempt country, and there are quite a few, you could make an application for intercompany transfer at a port of entry, which is a huge game
Oh,
changer because you don't have to go through a visa office or through IRCC to get it approved first. You can bring it right to the port, have a CBSA officer review it, and make a decision on the spot. The U.S. On the other hand, if you're Canadian, you can come to the border for your initial L1. They can make a determination on the spot. But if you are from anywhere else except for Bermuda, you will have to go through USCIS, get a petition approved, and then get a U.S. visa, where they will do another round of determining whether you are a manager, executive, or specialized knowledge professional, and whether this
right.
fits. So you get two adjudications for the price of one. And then you finally come into the US, and CBP can also look at it and determine whether you fit the criteria as well. So I think that is the competitive advantage that Canada has in this specific immigration application, is that you can get a person up and running usually faster.
Now, when you said at the port of entry, it jogged my memory to think of NAFTA, or at
Mhm.
least the new version of it. For TN visas, am I wrong in thinking that we're talking about Canadians going to the US, or Americans going to Canada? Does the L1 and the Canadian version more fit with, say, Europeans coming over or something? Because wouldn't your first gut feel would be that if a Canadian wants to go to the US, would you explore the TN option first?
I always look at the TN as an option. Sometimes L1 makes more sense.
Okay.
You have to remember TN is limited to 63 professions. So if you
Yes.
don't fit in there, you might have a wealth of specialized knowledge. You might have a bachelor's degree in something that just doesn't quite fit with TN. So uh, the other downside of a TN, especially if you're coming into the US from either Canada or Mexico, is that your spouse cannot work. They don't get work
Right.
authorization.
Right.
So
See, that's why
where
they pay. That's why they pay you. And I just asked the questions. You see. One thing I didn't ask on this slide or in the Canadian one. What about family coming with you?
So yes, family can come. In If they're coming with you to Canada, the spouse gets an open work permit upon application. The children get study permits. It's quite straightforward. It can all be done at the port of entry if you're visa free. Coming to the U.S., the spouse would get an L2, and then on the I-94 record, the spousal relationship is now designated, so the spouse can work as a matter of right of having this L2. The children get L2s as well, and they can enroll in school.
Last question for you is, if someone comes over, they've got the job in Canada, how long does that last? Because I know you mentioned 7 years, I believe, in the United States. What about Canada?
Yeah, it's the same. So,
Oh, okay.
manager or executive in Canada can work up to 7 years. A specialized knowledge professional can work up to 5 years. So, our goal, if it aligns with the goals of the client, of course, if they wish to become permanent residents in Canada or green card holders in the US, we should start having conversations about that early on so we can time the applications so that we make sure that they have had their chance to become a permanent resident before their intercompany transfer status expires.
Okay. You've got dozens sitting on your desk right now. Obviously, it's quite popular. Employers contact you for this, or is it more of an employee thing that they say, "Hey, I'm going to ask my boss to transfer. Can we do this?" Or how does it work for you?
I get it both ways, actually. Often companies will identify people that they want to move, but I was actually just talking with a couple in Montreal, and we looked at spousal sponsorship in the U.S., and we also looked at potentially transferring one of the partners because she didn't want to be unable to work for a period of time in the U.S. She wanted to be able to go to the U.S., have her own independent status, and work while this spousal sponsorship is actually processing. So it can sometimes be employee driven, but I find it's more often employer driven.
Okay. Thanks for this, Michael. Thanks for explaining on both sides of the border how this works. If you want to get in touch with him, that's MORourke@pacelawfirm.com. Michael, we'll talk to you soon.
Thanks, Sean. Take
Bye-bye.
care. Bye bye.